Long-term disability claims stem from a contract of insurance that exists between generally an employee and an insurance company. Now, that's not to say that you have to be an employee in order to purchase a long-term disability contract or benefits. That type of coverage exists, and you can purchase it either through an employment setting or individually. Many of these companies that provide it provide long-term disability coverage, and there are different levels of coverage. Now, most policies, and I can only give you a general overview of how these policies work, most coverages provide up to 66% of your income, okay? So they take your gross income and you'll get up to a maximum of 66%. However, it can also be based on your net income. So each contract is different. You have to speak to your either broker or the insurance company to find a policy that is right for you. Now, most people understand that this policy of insurance will provide coverage in the event that I'm no longer able to work in your own job. And frankly, that's the first part of the test. The first part in most of these contracts is that for the first 2 years, you have to be totally disabled. And what that means is that you have to be totally disabled from your own job for the first 104 weeks. Now, these policies also have an elimination period, which means that they will only start paying you after your disability affects your ability to work for more than 120 days or 90 days. That's called the elimination period, which you'll see referenced in your policy. But then once the benefits kick in, it'll pay for the first 2 years, provided you're unable to do your own job for 2 years. Where a lot of litigation arises is at or near the 2-year mark. That's when people start reaching out to my firm to discuss what their options are. Because at the 2-year mark, the test changes from are you able to do your own job to are you able to do any type of job for which you're reasonably suited for by means of your experience, your age, it's all kinds of variables. So it's at that 2-year mark that most insurance companies will terminate your benefits. Or they'll simply tell you that although you have a disability, we believe that you're still able to do another job, and as a result, we're going to terminate your benefits. So most litigation arises at or about the 2-year mark, and which then gives rise to 2 options. Your first option is to do nothing, which means that you'll effectively receive no further compensation from your insurance company despite paying for these benefits, or you can contact a law firm or a lawyer to litigate the denial. Okay, and really what this is and what these claims really are in a very basic sense are they're a breach of contract claim. You had a contract with an insurance company and they've breached it by failing to honor the terms of the contract. Now their position is that you're able to do another job for which you're reasonably suited, but generally if you're unable to do your own job, you're probably unable to do any job. Now, the question becomes, and often what people are more focused on, is their injury or their condition or their symptoms. That's not the test. Really, the test always comes back to this word impairment. Okay, impairment is really the test. And the test is focused on, are you able to do your job or any type of job? Whatever your condition is secondary. Sure, it helps inform whether or not you have whether or not your impairments reach such a level that you're unable to do your job or any job. But it's not specifically whether or not you have cancer or whether or not you have an autoimmune issue or whether or not you have a heart issue. It's all about the effects or the impairment that stems from those disabilities or conditions or injuries. Now, we see a big difference between physical claims and mental and behavioral claims. Insurance companies do not like or they deny more often than not any claim that involves an invisible impairment. Now, what is an invisible impairment? Well, those are things that you can't see on an X-ray. You can't see on any imaging. So what are those type of claims? Well, they're mental health issues. They're anything related to pain. Again, we don't have a machine where you put your hand in the machine and it tells you that your pain's 9 out of 10. So people that have fibromyalgia or chronic pain. We also see a lot of claims involving concussion. Again, we don't have imaging that says you have a concussion. We see a lot of claims relating to tinnitus, which is ringing in the ear, or vertigo, where you have dizziness, and even headaches. Again, these are all what insurance companies consider invisible impairment claims. And invisible impairment claims are much easier for insurance companies to deny because they just simply, although they don't advise you in these senses or in this paraphrasing, but it's effectively that they don't believe it, okay? Or they'll draw or they'll question your credibility. But what we do know is that these are legitimate disorders that create very significant impairment. And the test, no matter what it is if you can't work and you're totally disabled, then you qualify for your benefits. Part of what we do as lawyers is we make sure that we hold the insurance companies to the strict terms of their contract. And where we can add value is by not only making sure that you get the benefits that you're duly entitled to, but we also make sure that depending on the nature of the denial, we help get you what are considered punitive and aggravated damages, which is an additional amount of money to penalize the insurance company for their bad behavior. Now, you do have options in the event of a denial. You can call a lawyer and you can commence a lawsuit for your losses and for the benefits that you're entitled to by way of the long-term disability contract. We also can help access or help you qualify for Canada Pension Plan disability, which frankly most insurance companies require you to apply for it, because even though you think that this is a benefit that you've paid for through your employment, well, the insurance company actually gets credit for it. So if your benefit was $2,000 and your CPP disability amount was $1,000, it's not like you get $3,000. The insurance company will just simply reduce the amount that they have to pay you by $1,000, and you'll still receive $2,000. You may think that's perverse, but which it is, because now you and the government of Canada are subsidizing billion-dollar corporations. But that's how these insurance companies are written, and no one has changed the legislation to disallow insurance companies from doing this. So that's what the current state of the law is in Ontario. But in any event, if you don't apply for CPP-D, the insurance company will simply unilaterally discount what they owe you as if you are receiving it. So it's always best to apply, and my law firm helps with that. Other issues that arise when people are forced to apply for CPP disability is our government will provide you with a retroactive payment that will cover you back to the date that the date of the onset of your disability. That will result in potentially a payment of $10,000, $20,000, whatever it is. But that then puts you in hot water with your own insurance company, because then the insurance company says, you now owe us that $20,000. And if you've spent it, well, now you're going to have issues with your insurance company, and they will expect repayment. If you've had your long-term disability claim denied, or if your long-term disability carrier is making your life difficult with respect to your long-term disability policy and is asking you all kinds of questions that you're unable to answer, feel free to give my law firm a call for a free consultation. We'll help answer these questions that you have, and we'll also make sure that you're fully aware as to what your rights are under your policy, and we'll also articulate to you what we can do for you in a real sense.